thousands up into the tens of thousands that show from various platforms of varying sizes what they found, searching hashtags related to Madeline or Stephan Sterns. Same thing, more, we have up to 46.2K, as low as 380. And then Facebook, this is hard to see, but the groups on the left are all Facebook groups that specifically relate to Maddie Soto, and the groups on the right, the three groups specifically relate to Stephan Sterns. The groups are varying sizes, various names relating to Madeline, finding her, missing, thoughts and different topics of that nature. And then finally is Google searches, if the court wished to. Essentially, when you search their names, you can go to the various Google listings and all the articles that pertain to each of them. And then in some of the news articles, I just grabbed a couple. Obviously, we have various different news articles, but Court TV is a popular news station who has an entire page literally related to Stephan Sterns and various proceedings, including, as recently as this month, articles being posted as recently as last week, linking to others. And then Paula Neal Mooney has as well. In the podcasting area and some of the Google search, you'll see like Nancy Grace TV and various other media outlets. So that, coupled with the articles that defense was providing, show the various media coverage from local, meaning Central Florida, local within the state of Florida, outside the state, and locations and places that, honestly, I can't tell you exactly where they are, but for it's saying New York, Puerto Rico, or things like that from the news because of the pervasive nature of media and the ability to be anywhere at any time, not necessarily having to give locations as to that. So in terms of presentation of the media information, that's what defense had in terms of the PowerPoint, and otherwise we just have an argument.
Thank you. The defense has certainly established that there is a tremendous amount of media and social media interest in the allegations in Mr. Sterns' two cases before the court. The Miami Herald case gives the court some guidance as to what factors need to be considered in making a determination before a court may close its proceedings and operate in secret outside of the purview of the public and the media. There is a presumption that all pretrial hearings should be open ones. That is a fundamental tenet of the criminal justice system in the United States. Defense, I'd like you to curtail your argument to the considerations that closure is necessary to prevent serious and imminent threat to the administration of justice, that no alternatives exist other than a change of venue that would protect the defendant's right to a fair trial, and that a closure would be effective in protecting the rights of the accused. Obviously, the court must balance the due process right of the accused with unrestricted access to all judicial proceedings. Whenever you're ready.
I provided case law, I believe. Do you have a judge?
I've got a lot of case law.
I handed a packet that had 2 statutes and 3 cases, Rule 2.450, Rule 2.451, and then the 3 cases being Gannett Co. versus DePascal, which is a U.S. Supreme Court case, 99 Supreme Court 2898 from 1979, the Miami Herald versus Lewis case, which is a Florida Supreme Court case, 426 Southern 2nd, 1 from 1982, and then Miami Herald Media Company versus State, which is a 3rd DCA case here in Florida, 218 Southern 3rd, 406 from 2017. So looking at those 3 prongs which are established by the Miami Herald case, the defense would argue that the closure is necessary in this case to prevent serious and imminent threat to the administration of justice, because looking at rules 2.450 and 2.451, gives the court the ability to control the conduct of the proceedings before the court, ensuring decorum, prevent distractions, and ensuring the fair administration of justice. So as such, this falls within the court's discretion. The media in their response talks about openness and transparency as being needed to produce a disinclination to testify falsely, when in reality it creates nothing more than an air performance, as if the courtroom is nothing more than a stage. Yes, people have a right to know about what happens in court and the analysis that comes along with that from internet detectives and analyzers, many of whom aren't even in the state or potentially even looking at the laws that apply specifically within the state of Florida, or the case of this jurisdiction is an entirely different story. So essentially this prong looks at why, which goes to the jury instructions ultimately that, at trial the court will be looking to. Potential jurors are exposed to facts that they aren't supposed to be exposed through the publicizing of the case. Defense isn't requesting a full closure of the courtroom. We're specifically requesting closure as to the pretrial proceedings. So the 3 motions to suppress that defense has filed and will be requesting hearing time on are what we're kind of looking to in terms of that closure. And so in looking at the Gannett case, which is the U.S. Supreme Court case, they talk about, and in that case they found that the court's decision to close the courtroom was a balancing act, as the court indicated. Nowhere with that case specifically actually dealt with the motion to suppress, and the publicity concerning the pretrial suppression hearings in that case, similar to what defense would argue in this case, poses special risk of unfairness, because the whole entire purpose of a motion to suppress is to screen out evidence that was potentially illegally obtained or is otherwise unreliable in some manner or some fact that should not otherwise be known to the jury. And so So while the court should allow publicity in general instances during the pretrial hearings, like the motion to suppress, that can further influence the public's opinions against Mr. Stern and allow the public to, as well as the potential jury, to have inculpatory information that would otherwise be admissible in the actual trial. And so the danger of the publicity in allowing the admissibility or the publicization of that pretrial suppression hearing makes it difficult to measure what, if any, effects that would have on the actual proceedings. And the Sixth Amendment, which is codified through the 14th Amendment, talks about fairness and the openness of trial itself. Nowhere in the Constitution or common law does it specifically reference or refer to the access to pretrial hearings. So the access to trial, which defense isn't requesting trial be closed, we're specifically requesting pretrial hearings, isn't statutorily, constitutionally precluded. We're asking for pretrial. That's not a right that is guaranteed by the rules, by the courts, and that's found in the Gannett case, as well as further found in the Miami Herald Company versus State case, deals with the pretrial publicity. The second prong, Judge, that the court looks to is that no alternatives are available other than change of venue, which would protect Mr. Sterns' right to a fair trial. And looking at that factor, this is pre-trial, i.e. before trial, so the entire purpose of this would be in allowing for the closure of the courtrooms during those pre-trial proceedings. Hopefully and potentially it will prevent the need to change the venue in this case come actual trial, because of being able to limit and curtail the information that the media has access to, and that there are no other alternatives. As the court saw from the PowerPoint, from the various articles that I provided, the media is, and likely will continue to dissect any and every aspect of this case, from the public records request through discovery that was provided via the state, through the public records forum, through any motion and every motion that defense files in this case. And so defense would argue there are no alternative measures that would, other than changing venue, that would preclude or allow for Mr. Sterns to have a fair trial. And finally, closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. Again, defense is requesting only the closure of pretrial proceedings, such as motions to suppress in this case, not the closure of the court for the actual trial. And so we're asking for a limited nature of the proceedings being closed or foreclosed. In the cases that defense cited, some dealt with a motion to suppress, one dealt with specifically an Arthur hearing, and one even had a motion to suppress where the hearing itself was closed. However, after a certain amount of time, the access to the transcript was allowed to be gained by the media or those interested parties. So the court was able to, in crafting their order, limit both the time and the duration, the nature, as well as allowed a remedy to allow them to have access at a later point in time. I believe that was the Miami Herald versus State case, in which they dealt with that. So defense would argue that essentially, while pretrial publicity and the fact that there is pretrial publicity in this case, a lot of these cases that form the basis of allowing for the closure of the courtroom was pre a lot of the forms of media that we have now. TikTok, Instagram, Facebook, Reddit, podcasts. A lot of those mediums didn't exist back in the 70s and the 80s when these cases were decided, allowing for the court to allow restriction and closure. The pervasive nature of the internet itself and the exposure makes it to where the pretrial publicity, both the emotional aspect of it, should allow for this court to grant defense's motion to allow for the pretrial closure of certain proceedings subject to whatever limitations the court should impose, such as if the court were to grant closure for motion to suppress, for example, and allow at a certain period of time the allowance or the dissemination of that information, or if the court were to say motion to suppress are not allowed, no access to it, they hear it at trial. So defense would argue that defense meets the three prongs by the preponderance of the evidence, which is the standard that defense had to meet the prongs by as to each of the factors, and the court should grant defense's motion to close the pretrial proceedings.
Thank you, Ms. Smith.
Yes, Judge. In both parties, they talk about empirical data. However, if you look at the Miami Herald versus State case, the third DCA case, it specifically says that no case, the Lewis case, or nor does any Florida case suggest that a trial court must consider expert testimony or empirical data. So while they said that that has not been presented, that's not necessary in order for the court to rule that closure of a pretrial hearing is necessary to prevent imminent harm. The media interveners talked about, we're assuming that the coverage is negative. Judge, if you look at the articles that were introduced into evidence, the title of the articles, in the court re-reviews the PowerPoint, the heading and the titles of the articles, the podcast, all of that, it implies or is negative in nature. None of it is saying wrongfully accused or anything of that nature in those titles. The media interveners talked about this being a high standard, and the preponderance standard is one of the lowest standards in a criminal courtroom or in a criminal case. It's just more likely than not, so essentially a 51%. So the defense would argue that by preponderance, defense has shown each of the prongs established. There is no need for empirical data. Some of the other cases they talked about, I believe in those cases they were seeking complete closure of the media for all aspects of the proceeding. Again, defense is limiting this to specifically the pretrial proceedings in this case, where different evidentiary items could be found. The Miami Herald case, which the media interveners cite to and talk about a lot, the Florida Supreme Court case, the court did close the courtroom and that was upheld. All the cases that defense provided, the U.S. Supreme Court case, the Florida Supreme Court case, and that third DCA case, all are cases in which it was upheld that the closure that the trial court in those cases did was sufficient and was practical in light of the evidence and the cases that are presented. So defense would argue that based off the evidence and testimony that's been presented, that we have established by preponderance each of the factors or each of the prongs needed to satisfy the court that closure is necessary to prevent that serious and imminent threat, that there are no alternatives necessary or available outside of change of venue, and that the closure itself would be effective in protecting the rights of Mr. Sterns without being broader than necessary to accomplish the purpose. So we would ask the court for that motion.
Thank you, Ms. Smith.